SJC-13260, Commonwealth versus Carlos Colina.
Okay, Attorney Billowitz.
Good morning. May it please the court. Elizabeth Billowitz for Mr. Colina, and with me at counsel table is Jack Cunha, Mr. Colina's trial counsel. Mr. Colina was convicted of premeditated murder and improper disposal of human remains. He conceded guilt on that second charge, and he admitted to dismembering the victim's body post-mortem. However, his trial featured inflammatory rap lyrics written years earlier that mentioned dismemberment and other violent acts. The admission of these lyrics was squarely prohibited by this court's recent decision in Korea, which held that rap lyrics need to have a strong nexus to the issues to be decided in the case. That includes both a temporal nexus and nexus to the details of the alleged offense.
So as to the details, I mean, they're pretty spot on. So I'm assuming you're conceding that, or?
Absolutely not.
No, why not? I mean, it's about using a saw and the chokehold and all of the elements of what transpired here according to your client's own testimony.
I absolutely would contest that there is a strong nexus to the factual details of the offense.
Right, but why?
So the lyrics don't even approach the kind of unmistakable factual connection found in the cases where nexus was affirmed. An example is in the Holmes case. The lyrics describe tearing a necklace from a victim's neck, going through their pockets in a parking lot while wearing a ski mask.
What about V. Elvis?
I'm sorry?
What about V. Elvis as far as the dismemberment fixation? There's a lot stronger evidence in this case because V. Elvis was drawings. This is him saying stuff.
And I want to get to the fascination in V. Elvis. Is it okay if I first
sorry, I don't know if you finished
answer
Justice Wendland's question.
in
I'm
full?
sorry.
Because
Here, let me just cut to the chase.
Yeah.
I mean, some of the words here, and I excuse the audience who's watching, but I decapitated and dismembered his arms and legs. Isn't that what happened?
it is what happened.
I sawed off the neck from the head. Isn't that what happened?
Yes.
Okay, and then I strangled you in a chokehold, speaking to Johnny, right? Isn't that what happened? So let's move on to the temporal nexus. Why is that, and I'm sorry, Justice Gaziano, why is the temporal nexus a problem?
It's undisputed that these lyrics were written at least 3 to 4 years before the offense.
Well, let's take one at a time. What's the date of the demo CD?
The demo CD did not itself have a date on it.
Okay, so how do we know it's, what did you say, 4 to 12 years?
Yes.
Okay, so how do we know that?
Mr. Colina himself testified that he wrote it in 2002. The state trooper who introduced the songs testified that that was written in 2011 or
And
2012.
how does the state trooper know that?
I am not sure, honestly,
Okay,
what his basis
so
of
we
knowledge
have
is.
your client saying it was 2002. It was
Yes.
found during the search warrant. I guess I'm struggling to find the abuse of discretion in allowing this in.
So there was certainly no evidence showing that that was written more recently than 3 to 4 years ago. It was consistent with
Isn't
the
it
other.
Where was it
download? Isn't
found?
it? I thought it was downloaded again. He more recently.
Yes.
Okay, so that's.
So
Well, there's two things, right? Like I'm sorry to talk over, but I just want to get the temporal nexus questions answered. As to the CD, it was a physical object, right? So that was not downloaded, right? That was just found during the first search warrant as undated.
that's correct.
Okay, but what was downloaded was the second file, right? The caveus, the virus, right?
Right,
And
and-
that was the chokehold language and was downloaded within 3 weeks of the murder, right?
It was not, I'm not sure downloaded is the correct term. There is no dispute that those lyrics were written 4 years earlier because there was a dated handwritten lyric sheet. And what the digital expert testified to was that file
Was saved.
was last edited in January of 2012. It was copied, unchanged, unedited
3 weeks before the murder.
3 weeks before.
Okay.
Isn't that, but why is that not significant, that it's copied? I mean, I understand that we don't tend to resurrect things unless there's a reason, right? I guess it's copied in the context of a larger copying exercise, right?
He added it to other music that was contained on his desktop computer. So even if we assume that those lyrics were an expression of his state of mind when he wrote them, the simple act of copying them unchanged.
Why wouldn't we assume, for the benefit of argument, that they were part of his state of mind when he copied them?
Yeah.
I think that is
Unreasonable.
speculative. If I wrote a novel and kept it in my home office, and years later I took it to the living room and put it on a bookshelf with other books.
What about if the Elvis puts pictures of dismemberment on his wall, and we don't know how long they've been there, but there they are?
Well, having something visibly on one's wall, I would argue, is different from adding something to a collection among hundreds of other.
But now we're getting into abuse of discretion. That's the problem.
Yes, abuse of discretion is the standard. I do want to point out, though, if we look at the cases in jurisdictions applying the strong nexus test, I could not find a single case finding a sufficient temporal nexus when lyrics were written before the offense, much less years before.
And I wanted to ask you about that exact point, because it strikes me that it is and should be much more difficult to introduce rap lyrics or any kind of lyrics that are written way before a crime, as opposed to the kinds of cases you were talking about where afterwards someone describes in music what they did and the details match up. Obviously, no one is contending here that these were written after the fact, describing what did occur. So when do you think a court could find sufficient nexus when in the specific context of before the fact lyrics?
Well, this court in Korea mentioned a couple of federal cases that were used to show indirect nexus, familiarity with certain language. So there, if you're using, I think in those cases, there was drug lingo that was used in lyrics that were written beforehand. That was just used to show familiarity with the drug trade.
But they have to prove premeditation, too. That's one of the... So before is much more relevant than afterwards in proving intent, right?
That is what the Commonwealth sought to do. I want to just speak for another moment about the nexus to the factual details. Violence is ubiquitous in rap music. Even decapitation is not, or dismemberment is not unusual. In fact, the brother of the victim in this case, who was himself an aspiring rap artist, his lyrics included references to decapitation. And the details that are in these lyrics don't have any connection to the specifics of the offense. The demo CD track is a fiction.
It's got to be an overstatement. I mean, it's just, it may be too far on the spectrum, but it's pretty close,
Not the words decapitation and dismemberment, I agree, but they are situated in a...
Choking, dismemberment, decapitation, this isn't a shooting, this is a little different.
But the song that mentioned decapitation and dismemberment was a narrative about a shooting. It told a story about gunshots whizzing across someone's nose and then taking revenge on the shooter along with a companion. None of those details have anything to do with this case. So it's a fictional narrative. The other song, which Justice Wendland brought up at the beginning, the virus. He says at the beginning, Johnny, it was the fucking computer. That was a reference to problems they were having with their recording software. There wasn't anything about a computer in the offense years later. He then talks about the Bermuda Triangle, and then he says, I strangle you in a chokehold. These are not the kinds of unmistakable factual connections to the lyrics. I want to make sure I get to Veovis, which Justice Gaziano raised. The Commonwealth is arguing here that the lyrics were probative of state of mind and intent because they showed a fascination with dismemberment, which was also something that came up in Veovis. And the lyrics could, of course, only show his state of mind at the time that he wrote them, years before the offense. And Veovis doesn't control here. That case didn't, of course, involve rap lyrics, the unique risk of prejudice, and wasn't applying the strong nexus test.
Whoa, do you think it was more prejudicial to have the rap lyrics in than to have the diagrams of dismemberment in Veovis?
Far more prejudicial.
I guess Justice Lowy would probably agree with you, but he didn't win the day in Veovis.
That was an ill-timed retirement from my perspective. But I would say that the evidence also in Veovis was introduced for purposes that weren't at issue here. It was introduced primarily to show identity. That was not at issue. Motive was not, it wasn't posited here. And, you know, I would agree with Justice Lowy to say that Colina was fascinated by dismemberment and later acted in conformity with that fascination, not just by dismembering the victim, but by killing him. That is quintessential propensity evidence. In order to link a fascination with dismemberment to a premeditated murder, you need a series of inferences, and I would say that none of these is adequately supported. You have to infer that he was expressing a literal fascination with dismemberment in the lyrics, not just a fictional storyline or rap tropes.
But that presumes a purpose for which it's being offered that it wasn't being offered. What you're arguing and what you're setting up is if it were being offered on the issue of propensity. It wasn't being offered for that purpose. So to the extent that the Commonwealth had to prove intent in the state of mind of Mr. Colina, it's not being offered to show that he's just a bad guy that does bad things. It's being offered specifically on that issue. And again, so going back to the issue of the abuse of discretion, how is it not relevant to that issue?
Because there is not a sufficiently strong nexus under this court's recent jurisprudence in Korea. Not a strong enough factual nexus, not a strong enough temporal nexus. And so without that probative value, there isn't a legitimate purpose for these lyrics to be here.
I suppose, but is that an advocate's gloss, or is that the trial judge's abuse of discretion? Because as Justice Wendlandt went through, not only the rap lyrics, but again, you may disagree, but the fact that it was accessed in the weeks prior to, you can make the argument that the temporal is there, and even though you might say there's a larger narrative as to where those lyrics that Justice Wendlandt talked about, there's a larger story there, but nevertheless, in that rap song, they talk about, I'm cutting your head off, I'm dismembering you, and that's exactly what happened to this poor man.
In that song, it was the singer and another person dismembering someone. It was not, none of this was addressed to the victim in this case. But your point is taken. Even if we were to assume that these did have some relevance to his state of mind, the next problem is that these were more prejudicial than probative.
I would like, I actually find your sudden combat and provocation argument more compelling maybe than this one. Can you devote some time to that before you stop?
Absolutely. So the trial judge here refused to give manslaughter instructions based on provocation and sudden combat. Here, the provocation was a hard blow to Colina's face. And according to the model jury instructions, for both provocation and sudden combat, physical contact, even a single blow can suffice. So we take...
There's testimony from the defendant, right, that he had been beaten up before by the victim, right?
That's correct.
So he gets smacked in the face, and this guy, even though he's much tinier than he is, he's very tough, and he's beaten him up in the past. Was this presented to the judge? I'm a little confused of why the judge didn't give this instruction. I'm just trying to understand what was...
Yeah.
I haven't read the record on this yet.
So the judge, when this came up in the charge conference, she said that those instructions weren't warranted because there was no injury to Mr. Colina. And when it was pointed out that, in fact, there was injury and provocation actually doesn't require injury, she said the injury wasn't sufficient. So, I do think that misses the point here because, of course, we're taking the evidence in the light most favorable to
You have a
Colina.
question from Justice Gaziano.
Some of the cases, some of the domestic violence cases have that type of, Bianchi, have that type of concern. As I see it, the light most favorable is that there was an argument about rap. The victim slaps the defendant backhanded in the mouth, and he says very hard. There's an exchange of blows. There's a wrestling match, a headlock, and unconsciousness. That's a light most favorable to your client. Do I have that right?
Yes, and again, with the context...
And that he'd been beaten up by him
Yes,
in the past.
and that the victim was the alpha male in their relationship, that there had been fistfights in the past.
And your client was a much bigger person?
He was much larger, but this was not like, the domestic violence cases where there was,
275 pounds, right? And he's a really big guy. He's like 6'3", 275. This guy's like 5'9", something like...
Yes, they
He's
were...
really a tiny... There's a big mismatch in size.
There is a mismatch. However, the victim was strong. He worked as a baggage handler at Logan. He was fit. They were both intoxicated. So I don't think that issue is dispositive the same way as in some domestic violence cases or situations where it was an elderly or disabled person.
Can you distinguish Feliz and Escobar as far as reversal, if you have those cases on?
And is that about the prejudice when there is premeditation?
I forgot to, I don't mean to give a quiz, but yeah.
No. Glad I passed.
Why is it reversible error?
So the jury's premeditation finding doesn't preclude prejudice on these specific facts. And this court said in Commonwealth versus Sorois, I think is how it's pronounced, because deliberate premeditation can occur in a matter of seconds, a finding of deliberate premeditation is not necessarily inconsistent.
Well, what about the strangulation cases? We've been different in those.
Yes. Felix, I think, is the leading case on that. So
that's why I was looking at Felix for that proposition.
So the medical evidence in Felix was a lot more extensive and precise, and there the victim died from ligature strangulation, which would have needed application of a certain amount of pressure for 3 to 5 minutes. There also...
Was that also a domestic violence? I can't remember.
I'm sorry, but
Yes.
and here we have manual strangulation, right?
There was not a conclusive cause of death here.
For obvious reasons.
Yeah. So asphyxiation was ruled in as a possibility, but all that the medical examiner testified to was that would be a matter of minutes rather than seconds. Here, the sequence of events...
I guess the point I'm trying to make is that ligature strangulation would probably take less time than manual strangulation.
There was not anything to that effect in the record, and I also think that the context of the asphyxiation here is critical, because what happened was that Mr. Colina was trying to disable this attack on him and render him unconscious in this headlock because he felt under threat. That was the testimony that he gave. And there's no evidence here that he would have had to continue to hold him in order to cause his death after disabling him by rendering him unconscious. So this wasn't a situation like Felix, where the length of time for, to cause the strangulation was inconsistent with provocation. Like that sort of allowed a cool down time that just wasn't present here.
Can I ask one other related question? This, in the lyrics, back to the lyrics on strangulation, this wrestler who does this to people that is referenced in, doesn't that make that more relevant again? Doesn't this wrestler, doesn't he put people in that hold and shut them down, that exact same hold we're dealing with here?
Yeah, there was a reference to a professional wrestler. The trooper testified that he was famous for his chokeholds. That does not seem to be supported. Again, there's a line about the Bermuda Triangle. Like it rhymes.
I get the stuff that's not relevant. I'm just trying to focus on the stuff that is relevant.
Well, I think that's the problem here, is that we can't retrospectively cherry pick the lyrics that seem to have some connection years after the fact.
Counsel, there's one other thing with that. Before you got rerouted to the manslaughter thing, I'm glad we're back to the rap lyrics, as you started to make the issue or raise the issue about the prejudicial effect versus the probative value. In a lot of times when we're looking at the abuse of discretion standard, one of the things that we look to is whether or not you got a limiting instruction, and that helps us to analyze the abuse of discretion standard. And in this case, after it was introduced, you got the limiting instruction, right? And the trial judge said very specifically to the jury the only way that they were to use this evidence, right?
That's correct. Our position is, because there was insufficient nexus here, there wasn't any proper purpose for the jury to consider these lyrics, and so the limiting instruction, it can't make irrelevant evidence admissible. So there was no proper purpose to direct the jury towards.
That's a different analysis. That's losing on the relevant evidentiary issue. Now you're downstream from that, and now you're, as the person objecting to it, saying you're arguing the 403 analysis, and then you lose that, and now you get the limiting instruction. So we're downstream from whether or not it should come in for a proper purpose. So in terms of the 403 analysis, probative versus prejudicial, you got the limiting instruction. So how do we still now find an abuse of discretion?
Well, what we got was an overbroad and confusing limiting instruction, because it mentioned some of the purposes that it mentioned were not even at issue here. That could have only...
It's state of mind and it's something else. What's the other part of it? State of mind and modus operandi, isn't it?
It wasn't modus operandi. It was, I want to be precise about this. It was identity or identification, which was not at issue here. Knowledge, which is not at issue here. The lyrics didn't evidence any particular, knowledge of the act. So I would say that those were insufficient to mitigate the error. And, there are certainly cases where even when you have a limiting instruction, the prejudice is powerful enough that it overcomes that.
Thank you.
All right. Thank you for your time.
Thank you very much. Okay, Attorney Walsh.
Good morning. May it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex, appearing for the Commonwealth. The lyrics were properly admitted in this case because they had a strong nexus to the issues, and as noted, limiting instructions were repeatedly given to the jury. They were given 4 times as each of the Commonwealth sets of lyrics came in during final instructions, and also the defendant admitted his own song, and limiting instruction was given again. The lyrics themselves were also carefully limited. From the CD, Cavi's demo, 19 lines were introduced by the Commonwealth. As discussed, those lyrics have a very direct nexus to the facts of the case, that I decapitated and dismembered his arms and legs, saw the neck off from the head.
Can I ask you to address the temporal nexus problem with the undated CD?
Well, as said, the CD is undated. To address the question asked of my sister, how did the trooper know the date of the CD? My reading of that transcript, they had just been talking about the computer file. I think he may have been thinking of that when he...
Right, yeah, so I agree he can't possibly have known the date of the undated CD.
Correct.
But how do we know that it is within some reasonable time frame of the murder?
So the remoteness in time really is not dispositive of whether the evidence should be admitted.
So you'll concede that we just don't know the temporal nexus, but in the totality of what the judge could have considered, there was no abuse of discretion in allowing this in, even if it was written in like 1980.
We have no idea. It was an audio CD. I'm not sure he was alive in 1980, but
whatever sorry, I'm betraying my own
I
age,
think he was
but like
fairly
let's say
young
it was 19 or
Sure.
2000.
It was not clear what the date was. However, Correa instructs that rap lyrics are supposed to be interpreted as or analyzed as prior bad acts. So considering these as prior bad acts, remoteness in time is not dispositive of whether the evidence should be admitted, but rather cases like Pano make clear that a reviewing court focuses on the logical relationship between the bad act evidence and the crime. Here, the logical relationship and the nexus is very strong. Similar to Veo Vis, it was evidence that shows the defendant's apparent fascination with amputation and human dismemberment, offers an explanation to what would otherwise be inexplicable. And those drawings didn't have dates. The CD here didn't have a date. The focus is on the nexus between the bad act and the crime at issue.
Can I ask you about the lesser included offense and whether or not you concede it was error not to give the instruction?
On provocation.
On provocation and sudden combat?
So, no, we do not concede that there was any error there.
All right, help me understand this.
Sure. A theory of reasonable provocation requires an objective showing that the precipitating event would have provoked heat of passion in the ordinary person.
Okay, so as I laid out earlier, as I see it, they passed arguments, but anyway, there was an argument about music. The victim slaps the defendant on the back of the hand with a mouth, gives him a backhand in the mouth. It's very hard. There's an exchange of blows, and they engage in a wrestling match, right?
Correct. I think
You're
this...
saying that's insufficient to constitute loss of self-control?
Yes, I think this case is fairly similar to Felix. In that case, the victim lunged at and punched the defendant. The court described that as a very weak provocation. But I understand.
That was error in Felix.
I understand.
So that's why I asked you to consider whether or not you're going to concede error.
Respectfully, I do not think it was actually found to be error. Rather, the court skipped that question and
So,
said...
yeah, even if, yeah.
Correct.
But
So
let's
again,
not skip it. Tell me if it
Sure.
was error.
So I do think that the provocation, the precipitating event was insufficient. He slapped me, backhanded me in the mouth, so we have a slap to the face. And then the defendant says, I got up angrily, this is on page 82, I got up angrily and defended myself. He threw a blow at me. So it was a slap, and then the defendant did something to defend himself, and then there was a blow. I do not think the physical confrontation started by the victim standing alone is not enough for reasonable
I'm
provocation.
confused by that, though, because isn't this the classic sudden combat? These guys are friends. They're arguing about music. The one guy, even though one guy's much bigger than the other, this isn't really a domestic violence type of situation because he says we also have evidence that he's beaten up the defendant previously. I don't get why this isn't...
As to sudden...
why it doesn't isn't this a typical one of these things?
As to sudden combat specifically, for that, not just provocation, for sudden combat specifically, it requires that the victim pose a real risk of serious harm to
He
the
says
defendant.
he got beat up by the guy previously.
Well, Benson and some other case law instructs that that's actually not a relevant consideration. Benson was a stalking case where the defendant said, I was so scared of him.
Leave out the domestic violence cases.
It's not a domestic violence
okay,
case.
so-
Benson was not a domestic violence
Okay,
case.
go ahead.
And Benson instructs that even ignoring the precipitating event just for the moment, Benson instructs that the question of whether there was sufficient provocation to warrant a manslaughter instruction depends on a number of timing issues. First, the sudden loss of control by the defendant. Second, considering the victim's last overt act only. The court there saw that this stalking relationship that left, and it was not domestic. Actually, the conflict itself, there was a new boyfriend, and the new boyfriend was giving the husband a hard time, but it wasn't a conflict between domestic partners. One of the involved men testified that the other involved man was stalking him, and the court did not take into account that relationship, the stalking incident. It said the last overt act. What did he do when he came to your house that time? And then finally, and critically, the third element discussed by Benson, for there to be provocation, the killing must occur before there was sufficient time for the defendant to cool off. And the case law is clear that manual strangulation requires sustained force over a prolonged period of time.
It's similar to Justice Gaziano's thing earlier, which is, okay, I'm in a fight, and this guy has the way of, he's fighting this guy who's a tough guy, and his way of shutting him down is putting him in that chokehold that we tell cops not to use anymore either. And he does that because the guy is angry and a real fighter, or whatever the term he uses. That doesn't get you those instructions. In our cases, well, I'm going to go back, and I have to read all these drunken brawl cases we got. But don't we usually get this instruction in that context?
Reading Felix and Benson together, especially considering the nature of the strangulation, those cases show that the killing has to occur before there's sufficient time for the defendant to cool off. And that's to get the instruction. That's not just considering the sufficiency of the evidence. It says that in the...
Where's the opportunity to cool off when they're engaged in a fight?
Because...
I can see we've had breaks in the action, and where we have a cooling off, someone walks away, or.
The instruction.
But here's one fight. I don't get the cooling off part.
Well, I mean, it wasn't really one fight, right? Like, it was a slap, and then some action by the defendant, and then a punch, and then this.
I don't know if I agree with that, but it's a sequence of
was-
events.
it was
There's
the defendant-
a physical, there's an argument, a slap, wrestling. That seems to me to be one event.
On page 82 of the transcript, the defendant on cross-examination is very clear each element of the fight and how it progressed. He slapped me, backhanded me in the mouth very, very hard, and then I got up angrily and I defended myself. He threw a blow at me. We started exchanging blows, and then he...
That isn't a classic fight. I'm not a brawler, but that seems like a regular
The
fight.
issue is really not whether it's a classic fight. The issue is whether there was a reasonable person in the defendant's position would have lost control in the heat of passion to
I
warrant.
thought your argument was more about it took so long to actually strangulate him that he could have, that was when he had time to cool off.
That is certain. I think that is.
That might be your better argument,
that is the
because the idea that the defendant narrated this as a sequence of events means that there was time to cool off seems incredible.
No, I'm sorry.
Yeah.
I am arguing, based on Benson and Felix, that and Benson makes it clear, because Felix is sort of resolves on prejudice, skipping the issue, but Benson, it discusses it as whether it is sufficient to warrant the instruction itself, depends on the timing factor of whether there was sufficient time to cool off.
And here the testimony, just remind me on the medical examiners, for how long did it take to hold him in a chokehold?
So the medical examiner, Dr. Welton, testified that asphyxiation takes minutes, not seconds. So he wasn't terribly specific, but certainly minutes is more than enough time to cool off.
Can he tell, you know the record better. Does he describe that he keeps him in this hold because he's still resisting? Because if that's the case,
No.
then he's got him frozen like that because he doesn't want him to get out of that hole?
The defendant says that he quickly got the upper hand, had his arm around his neck, leaned into him with all his body weight until he was restrained and no longer moving, and he says the fight lasted 40 to 50 seconds. And if I may, on cross-examination, he also admitted that his goal, he put him in the chokehold to win the fight. He did not say that he was doing it because, he had, on direct, I'm sure says he did it because he was scared. But on cross, which again, it's a reasonable person.
Win the fight, does that cut both ways? That because it's just, otherwise he's going to lose the fight.
Well, he quickly gained the upper hand in the fight, and he could have let go. I'd also draw your attention to the fact...
But for the instruction, we have to view it in the light most favorable to the defendant. I mean, that's certainly open to the prosecution to argue, but...
The defendant's own testimony established that during the fight, it is not crystal clear whether this was before the chokehold or after, but before the victim was dead, the defendant testified that he could have left his apartment. He said on cross-examination...
That's your self-defense case.
But it also shows that the defendant was putting the victim in a headlock and leaning his weight...
Let me ask you,
I'm sorry.
are you saying as a matter of law that sudden combat is unavailable in a case of manual strangulation?
No, I'm saying that sudden combat is, I think it's rarely available. I think that, sudden combat, risk of serious harm, I'm really talking more about provocation. I think that's sudden combat.
Well, sudden combat's a subset of provocation.
Of course. I'm not saying, there's no case that explicitly says, but they're at odds. The amount of time that it takes somebody to kill somebody by asphyxiation.
To me, this all goes to whether or not there's prejudice to get a new trial. As we said, the feebleness of the...
I do understand that, and I certainly see Your Honor's point. It's just that I would draw your attention to Benson, where it does say that that is relevant consideration, not just for prejudice in terms of getting the instruction, but that it should be considered.
This is awful close.
I respectfully disagree with you. Looking at the case law with Felix and Benson.
You wouldn't tell one of your trial attorneys to fight a sudden combat instruction, would you, on this?
Not sudden combat. I would fight sudden combat. I mean, the defendant here, I would suggest, got more than he even was entitled to. The self-defense instruction was really not even required because the defendant himself testified that he had the ability to leave the fight, and the right to self-defense arises only in circumstance.
Can you help us? Say you lose. Tell me why there's not prejudice here.
Well, Felix makes it...
Say you lose. Say we think a judge should give this instruction because it's damn close, if not required. Why is there no prejudice here?
Felix squarely addresses that with going to what Justice Gaziano has repeatedly said, that it goes to prejudice. Felix said, as this court found, even if we were to assume that there was error in the lack of provocation instruction, the error was not likely to have influenced the jury's conclusion because the time required to strangle the victim with a ligature, and again, here's manual strangulation, required a finding of deliberate premeditation inconsistent with sudden provocation.
Are there any chokehold cases that support that? Because I understand, again, and Justice Gaziano is more familiar, was Felix the case where the person was using the halter top to choke the victim?
I think...
and
I'm not sure what tool was used. It was a domestic case where
I thought he took her shirt and he was choking her.
I think that may be Felix.
That
may be Steve's. I'm not.
But
I think that might have been Bianchi, but that's...
Okay, are there any chokehold cases, literally, because at one point we had all these people using this, the cops were using this chokehold to shut people down, and are there any chokehold cases where we make the same point as opposed to these ligature cases, which are more classic?
I'm not. I didn't really make that distinction in my research between ligature and manual, but Felix, Steve's, Benson, all of the cases, basically asphyxiation, however it's effectuated, takes time that is inconsistent with provocation. So they don't really, the fact, whether it's manual strangulation or a ligature, the point is it's time. It takes time to asphyxiate someone.
It also takes time in that chokehold to shut them down because it stops the fight.
it stops the fight, but you could end the fight by letting him breathe again. And instead, the defendant testified that he spent 40 to 50 seconds leaning his body weight into him.
Is that the answer, that because of the way this chokehold works, although I assume we don't have expert testimony, at some point he's incapacitated and wiped out, and he could stop without continuing to kill him? Is that?
Of course.
Okay,
I mean,
but
we didn't
Is there
have.
anything in this record that supports that? I'm just, again, because
I don't know. There was not expert testimony on the specifics of how asphyxiation worked beyond Dr. Welton testifying to the amount of time that it takes.
Okay.
But the judge going to your question about whether you need to reverse, and the answer lies squarely in Felix that you don't. It addresses pretty much precisely that question. It doesn't raise that issue of expert. Are there further questions on this, or should I move on to the lyrics?
You can move on.
We discussed remote listen-in time. One thing that I would like to stress that I'm not sure was really in the brief, in terms of prejudice with these lyrics, in addition to the repeated limiting instructions and the judge limiting the evidence the Commonwealth was allowed to admit, this really was not a theme of the Commonwealth's case at trial. The Commonwealth's opening it was 23 pages of transcript. It refers to rap in 9 lines. The cross of the defendant is lengthy. It's about 125
I
transcripts.
thought it's important to the premeditation argument, because from what I remember of this record is he can't get the person into the bag, so he dismembers him to get him into this container he has. But you're using the rap music to prove premeditation, that he has a fascination with dismemberment, as opposed to I choked him, which gets into the manslaughter issues. He died, I'm surprised, and then I had to conceal my crime by. I thought you used the lyrics to prove your first-degree murder point.
Correct. So there were 2 sets of lyrics. One discusses dismemberment and decapitation, and one discusses strangulation. Both were admitted. Of course, walking in, to the trial, we didn't know whether the defendant would testify. We didn't know any of this would come out. So the Commonwealth's theory of the case was supported by the evidence that he was fascinated by decapitation, dismemberment, and asphyxiation.
So it is an important part of the case, then.
It was minimally used by the Commonwealth.
Well, what's the proof of premeditation? These guys are friends. They're arguing about rap music. They get into a fight. It gets out of control. And the defense is, I panicked and I couldn't dispose of the body.
So the evidence of premeditation argued at trial was the cover-up, the fact that the defendant very thoroughly cleaned the house, the room, and did not take any action to get help for the victim. And also the Commonwealth highlighted the defendant's own testimony that he could have left, and he did not, that he admitted on cross-examination that he could have left, did not, because he was in his own house and he wanted to defend himself in his own home, and that he wanted to, quote, win the fight. So that was most of the evidence of premeditation.
But isn't the most important evidence of premeditation the rap music?
I would say it is not, but before the defendant testified, we didn't have his statements, and so that was part of what the Commonwealth planned to use to show premeditation, was this fascination.
And the timing, the nexus, is much more provable on the strangulation than it is on the dismemberment, right?
Correct, because we have the date that was.
And we have the copying of the strangulation rap music.
Correct.
As opposed
That
to
it
the
was-
other one, we have nothing.
There was-
The other one's really old. The dismemberment stuff is.
Well, we have no way to know. It was an undated CD. It could have been a week before. It could have been 5 years before. We don't know it was old.
Where was it found?
The CD?
Yes.
In the closet. But this is a 400 square foot apartment. I mean, I don't know that being in the closet.
I'm just curious.
Versus under the bed. I mean, there's only so many places things can be. But yes, it was found in the
Doesn't
closet.
the defendant testify about how old the CD is?
The defendant does testify that it's older, but that was not known to the judge at the time she made the decision to admit it. And I would also argue that it's of very little consequence. The drawings in Veovis, we have no idea how old they were or when the defendant made the decision.
Weren't they up in his house when he was arrested?
There was a collage hanging on the wall.
What about the issue that was raised by counsel about the shapelessness of the limiting instruction? Because the judge in this case does what we've told judges a million times to stop doing, and stop giving all of the reasons why we say you can introduce what would be otherwise propensity evidence to localize it to what's at issue in this case. And in this case, according to counsel, I mean, you know the record a little bit better than I, when the limiting instruction comes in, is it just the litany of all of the stuff under that it could be relevant to, but not necessarily relevant to this case?
I respectfully disagree. I do not think it was a litany of categories. It was 4. She gave the same limiting instruction 4 times, and it was state of mind, identity, intent, plan, and knowledge. And I think that those are all valid considerations.
Identity?
Prior to the defendant testifying, we didn't know that he would admit that he was there. I mean, I think it does tend to, yes, of course he was in his apartment, but I don't think that was completely unnecessary. I think that was within her discretion to give that one, and she did not give everything. She gave 4 specific categories and repeatedly gave them, and they are similar to what was given in Veovis, which I believe had 3 categories, and there was one that wasn't given in Veovis. I see my time is up if there are any further questions.